What is up, everybody? It is your favorite lawyer, Chloe Corbett, aka the Duchess of Justice. I'm here with my dad, Augustus Corbett, and we have two big topics that we're going to discuss with you all today. The first is, why does the GOP keep attacking Black rights? We're going to get into that in a very big Supreme Court case that we're going to be analyzing in this video. And secondly, is bail reform. What is going on with bail reform in this country? If you're interested, stay tuned right after this. Hey, y'all,
All
what's
right,
up?
all right, all right, all right, all right. So, Chloe, sorry for interrupting you. Go ahead, take it over. The
What's up? I was just going to say it's the Duchess of Justice, and I have with me,
Minister of Justice, Augustus Corbett.
yes, and we are your the Defiant Lawyers. We provide legal analysis of trending politics, policies, personalities, and pop culture. So, y'all going to get all of that on this channel in these videos that we come up with. We provide legal analysis, we do commentary, and we just discuss issues that affect the Black community. So before we get into today's topic today, why don't you all go ahead and hit that like button, subscribe, and welcome to all of the new people who are viewing us for the first time today. Welcome, welcome, welcome. We love it.
Welcome, welcome,
With
welcome. Good to see you
with
all.
that, yes. How's it going, Pops?
It is going well, Chloe, going very, very well. My thoughts and prayers, first and foremost, are with the folks down in Florida. We got family
Yes.
down there. So, we
Yes.
first and foremost just send our prayers and well wishes to all the people who were impacted by Ian. In fact,
Yes.
Chloe, we had family in several parts of Florida, and we got family in Savannah, Georgia. And, Ian kind of went throughout all that area. And of course, we have a bunch of family in North Carolina, but I think North Carolina is not going to get any of Ian. But anyway, everyone who has been impacted by this storm, we send our heartfelt prayers and well wishes.
Yeah, I was just in Tampa last month. Absolutely love this city, by the way. Tampa is amazing. I had never been before. But it struck me just how much Tampa is surrounded by water. Where I stayed, it was right off the river walk, and then you have the beach right there. So my prayers are going out to the citizens of Tampa, the rest of Florida, anyone else who's been impacted. And we will keep you all in our prayers. And I'm glad that it doesn't seem to be as bad as what was expected.
It was
Um,
it was pretty bad though.
it was pretty bad. It was. It
Yeah.
was. It was. But yeah, so I'm just praying for anyone who was affected by it.
Yeah, I mean, it always can be worse, and that's the thing that we have to be thankful for. Even when we're going through tough times, they could be a lot worse. So we
Yeah.
thank God that they weren't, as bad as they predicted. I think sometimes the officials will, really emphasize how bad something is going to be, so that people will take them seriously.
Yeah. Yeah. Because we don't want a repeat of Hurricane Katrina either,
That's
or
right.
Hurricane Maria out of Puerto Rico.
Yes, and about 10 or 15 others that I could name. Having grown up in North Carolina, I think I've gone through 50 hurricanes in my lifetime, if not more. And the one that I remember the most, there were two actually, Chloe. You were much younger, but it flooded where
I
we were
remember
living. Do you remember
we were
that?
at church. We had to stay at church for what? Like, I remember it being a few days, it felt like.
Yes, we did. We opened the church to the community, and people from the community came in because our church was in this cement building, so it,
Yeah.
it could stand anything a hurricane would bring. And some of the folks needed a more secure place to sleep. So yeah, every hurricane we would open our church up to the community.
Yeah. I still remember that to this day, and I was very, very young. But hurricanes are no joke, and they stick out. So again, our prayers go to everyone impacted by Hurricane Ian.
Well, since moving here to Texas, not only, um, have I now, I'm accustomed to hurricanes, but now I'm very familiar with tornadoes.
Oh man, me
And
too.
actually, the winds of a tornado are greater than the winds of a hurricane.
Mm.
It's just that the hurricane lasts longer and just sits there and dumps all that water and all of that. The seawall here with Ian, they predicted would be like up to like 15 feet of just a wall of water coming down on the seashore. But I don't think it got that high. Still did a lot of damage from what I understand. But yeah, the tornadoes, man, will just come in and destroy stuff, and then it's gone.
Yeah, it's like a bam, quick there, then it's out, but and then it leaves all the destruction in its wake.
Yep, exactly.
So, Lord,
All right, so why does the GOP continue attacking black voting rights? That's what we want to start out with today because this coming Tuesday, October 4th, mark your calendar. And I need you all to be praying. This coming Tuesday, this coming Tuesday, October 4th, the United States Supreme Court will hear another case having to do with voting rights, having to do specifically with Section 2 of the Voting Rights Act. Um, the Voting Rights Act was passed back in the mid 60s to enforce the 15th Amendment so that African Americans could vote. And since then, cases have come out of Alabama. And this case that is going to be before the court on Tuesday is an Alabama case, Chloe. I mean, these cases tend to come out of the same place, out of the same places. Typically, they're in the South, not necessarily, but most of the time, they're southern states. North Carolina, South Carolina, Georgia, Alabama, Texas, Louisiana, less, but Florida, you can predict which of these states will uh, attack, black voting power. So this case is coming up October 4th, is coming out of Alabama. And I got some things I want to show you all about this case because it is really, 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 really important. And here's what we need you all to do. We need you all to show up here every Saturday because we're going to school you. We're going to educate you every time. Okay? We're not going to waste your time with foolishness.
mm-mm.
We're not going to, spend time talking about something other than what empowers you and empowers our community. We're going to take our legal knowledge, experience, and training, and we're going to use it to make you the better. All right? And there's nothing more important. Chloe, can you think of anything more important in our democracy than voting?
No, voting is the basis of our democracy. Voting is the reason why this country came, established itself from the British monarchy because of voting, because we didn't have representation in the English Parliament. So voting is the foundation of our society, of democracy, and it's something that we need to continue to demand be protected.
All right, so very well stated. The case that I'm referring to is Milligan v. Merrill. And I have the title of the case superimposed on Chloe, what do you think this is? What do you think this background is?
There has to be a Confederate flag.
It is, but it's
Yeah.
also something else.
Alabama's flag?
It's Alabama state flag.
Yeah.
Isn't that something?
Not surprising at
2022.
all.
2022, an Alabama state flag is basically a big Confederate flag.
Mm.
Now, this is what look, I'm not from Alabama. I did my research. This is the flag that Google said is the Alabama state flag. Now, if I'm wrong, please, Alabamians, forgive me. But this is what I was told based on my research. This is the flag. This is their flag. So it doesn't surprise me that they would continue their assault on the Voting Rights Act. And that's what this is all about, the Voting Rights Act. In 2012, the biggest case to weaken the Voting Rights Act came out of Tennessee, Shelby County, Tennessee, versus versus Holder, and it gutted. And it gutted. Wait a minute. Let me see. Let me make sure. Shelby County, Tennessee. I don't think it was Alabama. I think it was Shelby County, Tennessee. It gutted Section 4 of the Voting Rights Act, and basically, and I explain this every time I talk about the Voting Rights Act because I want people to understand it, Chloe. I want folks. We both so badly want people to understand how important this is. This is so important. This is so important. Our ability to vote literally hinges on the Voting Rights Act and the 14th Amendment. Literally.
And the most restrictive voting measures coming out of southern states, as you pointed out, are also states with the highest Black populations. So that's not a coincidence, that's by design. And that's what we're going to be talking about today. And that's the basis of this lawsuit that these Alabama voters brought against the state legislature out of Alabama.
All right. So that's a beautiful segue into it. Before we go there, let me just finish again with Section 4 of the Voting Rights Act. Basically, the Voting Rights Act required the past tense because it was gutted by Shelby County, the Shelby County case. But before Shelby County, southern states, the states that had this history of Black voter disenfranchisement, before they made changes to their voting laws, they had to get pre-clearance or pre-approval from the Department of Justice. They could not implement any voting changes without first getting approval from the Department of Justice. And that is exactly what the U.S. Supreme Court struck down in the Shelby County case. And it was right after Obama had been reelected. So the court basically said, the court basically said that with Obama getting reelected twice, what is the point of having a Voting Rights Act? I mean, it's not needed anymore. So they handed that case down. And then not long ago, there was another case, Chloe, you remember we talked about it, the Brnovich case, where they went at Section 2 of the Voting Rights Act. And this is what they're going after this time, voting Section 2 of the Voting Rights Act. Now, this doesn't have directly to do with people casting their votes. This has to do with Black voting districts. How many Black folks from Alabama will be in the U.S. Congress? And if this case goes wrong, which we predict it will because of the 6 justices up there, right? Conservative justices. If it goes wrong, it will not only impact Alabama, but states across the country will use its holding to do the same thing Alabama has done. Now, let's talk about what Alabama did. Chloe, as you pointed out, Alabama is 27% African American. That is over 1/4 of the state. Alabama, 27% black. Now, if you're being fair about it, blacks therefore should control at least 1/4 of the voting districts. There are 7 voting districts in Alabama. Black Alabamians, however you say it, Chloe, controls just that one part right there. So, of the 7 voting districts, the Alabama legislature drew up a map, this map, that gave 6, that resulted in there being 6 white majority voting districts and 1 black majority voting district. That's 1 of 7. That is not 25%. That is more like 15% or so. So the map that they drew up diluted black voters' power in the state of Alabama. And if the court lets them get away with that, then other states who want to stop us from voting will follow suit and pass similar voting district maps. Now, just a little bit of procedural history here, real quick, that I think is very important. And that is the lower court where this case originated. In fact, it was like 3 cases or 2 cases consolidated, ruled with the plaintiffs. The NAACP was involved and said, no, this is wrong. This is racial gerrymandering. That's what the lower court said. And the lower court further said, they issued an injunction and said, basically, Alabama, you cannot use this voting map for your election. Well, Alabama appealed straight to the U.S. Supreme Court. And guess who is over that area? Which justice? Clarence Thomas. And he and conservatives said they basically stayed the injunction issued by the lower court, and they said, no, Alabama can use this voting district. So the result of that is one African American, and I think her name is Terry Sewell, and I think Artir Davis was, I think, before her, I believe. But anyway, one African American out of 7 in a state that's 27% black, as you pointed out. Okay? So that's where we are with this case, which will be argued Tuesday. Now, one little silver lining here, Ketanji Brown will be on the court when this case is argued. So this will be the first time in American history where an African-American woman will be sitting on the court, and her first case will be this very, very important case.
Yeah, that makes me excited, and it makes me excited to read whatever opinion she might put out in regards to the case, and the questions that she asked of the attorneys who are arguing the case. If she asks any questions, we know that some justices they ask more questions, but Justice wow, the other black justice, his name is escaping me, Clarence Thomas, he's been known not to ask a lot of questions of the attorneys who are arguing the case. So I'm interested to see what side she takes, whether or not she's more vocal or less vocal when hearing the cases. But and also that in regards specifically to this case, one of the big arguments is also that there needs to be another black district out of the 7 districts out of Alabama, because like you said, the black population of Alabama is 27%. So to make that their representation more equal in the legislature, the plaintiffs and other supporters of the plaintiffs are arguing that there needs to be another majority black district to even things out and to make the representation equal to the black population out of Alabama. And like you said as well, the Alabama Supreme Court sided with the plaintiffs. They sided with the opponents of what the Alabama legislature is doing. And it's the Alabama state legislatures that, appealed that decision up to the Supreme Court that's leading us to what is going to occur next week. And to me, it's pretty interesting that I don't know the specific makeup of the Alabama Supreme Court, but I
Well,
would.
well, actually, it was the lower federal court that
Oh, okay.
that issued the opinion, and ironically, two of typically, Chloe, with the lower court, it goes in front of one judge. In this instance, it went. There was a three-judge panel. Two of them were Trump appointees.
Yeah. That's what I was getting at. Um I figured, I presumed that they would be conservative justices. So it's ironic that conservative justices even saw what Alabama's trying to do with suppressing the black vote. So we'll see what the conservatives on the US Supreme Court think.
Come on, we know what they're gonna do.
I mean, yeah, we do.
I mean, yeah, those
We
Trump
do, unfortunately.
appointees. I mean, the Trump appointees on the lower district court. It was so glaring.
Yeah.
As you pointed out, 27% black population, and only one voting district. That out of seven, that's just mathematically indefensible.
Yeah. Cuz I would argue 27% is even closer to one third,
Exactly. I would agree.
30%.
I mean, I
I
would
mean,
agree.
math, you're taught in school to round up, so I would argue it should be one third of the representation.
Right. So as you pointed out, the plaintiffs said we at least should have two voting districts, majority black voting districts.
Yeah.
Um, and but what these states will do, these GOP dominated state legislatures will bunch all the majority black voting district in one tightly concentrated area, so that they are not really voting in majority white districts, so that dilutes our voting strength in those states. Again, it's
It's
called
sad.
racial gerrymandering.
Yeah. And what is so, just on a larger scale, or, maybe a deeper scale, we always talk about this country being founded on the principles of the Constitution and how we were founded and justice and all of that, and breaking away from the British monarchy. And the whole reason why we broke away was, one, religious persecution, but also voting, not having representation in parliament. So parliament are passing out all of these laws that affected the 13 colonies in this newly developed country to be, but they had no representation of what was going to say and what impacts them. Yet they do the exact same thing to black people in various states, to, make all these laws that affect us, that mostly negatively affect us, yet do all this gerrymandering, try to scrub away the Voting Rights Act and other protections, to keep us from voting and to keep us from having to say what happens in our communities. It's just so sad, and the hypocrisy is so big as well. I mean,
That's an excellent point. I I wrote a Facebook post a couple of days ago where I talked about the contradictions of our country, right? The Declaration of Independence.
yeah,
We hold these truths to be self-evident.
all
That
men are created equal.
all men are created equal and endued with certain inalienable rights, the right, to life, liberty, and the pursuit of happiness. And then those same men wrote in the Constitution a bunch of slave clauses,
And they were slave owners.
and they were slave owners. Our what the Pledge of Allegiance, or the Pledge of Allegiance, one God, one nation under God, indivisible, with justice and liberty for all. And while that was being written, they were at the same time creating a Jim Crow apartheid system. So yes, you're right. The country is a great big contradiction. And I
Yeah.
love it when white evangelicals talk about this country being a Christian nation, founded on Judeo Christian principles. And yet they broke every commandment, all 10 commandments, all of them, in their treatment of people based on the color of their skin. So you're absolutely right. Absolutely, totally right. Now, what I want to remind folks of too here before we go to our next topic is we are just a little bit more than a month away from voting, midterm voting. November the 6th, I believe it is. Let me make sure. Help me out, somebody.
Let's see, midterm. We know it's in November,
It's that first Tuesday in November. It's
November
November
8th.
8th this time. That's right. You know, a lot of times it's on the 6th, but I didn't
Hmm.
want to say I want to give the exact date. No, I don't want to do anything to keep folks from voting on November 8th because it's really important. Um, if the GOP takes control of the House and or the Senate, and you can just kiss goodbye any type of measure to benefit African Americans. Just kiss it goodbye. Gone. Period.
Peace.
Bye bye. Over and done with. So, and Chloe, it troubles me what I hear coming from your generation, from some folks in your generation. Two things. Two things. One is this tension between black men and black women.
Hmm.
There are. Let's go to the state of Georgia. I read recently there are some ignorant African American men who are saying that they're not going to vote for Stacey Abrams because she's a black woman. I mean, and these are not, I don't think these are GOP folk. These are just ignorant. I mean, just dumb black men who are playing into that foolishness, on the theory that black women are doing so, they doing good, they doing much better than me, black women, black woman vice president, black woman this, black woman on the Supreme Court, black woman that, what I'm gonna vote for. And didn't they do the same thing to Karen Bass out in California?
Yeah.
Same thing.
That's why you have a lot of black women saying, well, we're going to stop caping for black men, meaning we're going to stop, something happens, unfortunately, a police brutality shooting or something. Let them handle that. Let them represent. Because a lot of times it is black women, one, who are more vocal, especially for the Democratic Party. I mean, we see what we did out of South Carolina for Joe Biden. Um, a lot of times we're the matriarchs of the family. So, I mean, having that mindset when black women are so important to the black community, it blows my mind. But I also know that it's by design because us being divided, it makes us weaker and it makes us not pay attention to voting and our voting rights potentially being decreased and not putting businesses back in our communities and helping with criminal reform and all of that. So I believe it's by design, Dad.
Well, sure. I mean, what Willie Lynch? The Willie Lynch syndrome is what it's been commonly called. Where I don't know how factual it is, but uh, that there was an actual man named Willie Lynch who taught plantation owners how to divide the slaves to control them, divide them along gender lines, light skin versus dark skin, um, you know, those who worked in the house, those who worked in the field,
Yeah.
the younger versus the older. And you see that. But common sense should tell you to reject that. I mean, brothers, uh, Georgia brothers. You brothers out in Georgia, you mean to tell me you rather have Brian, what's his name, the governor out there?
Um, I don't remember that. Let me see.
Me neither. I'm not familiar with Georgia politics. I typically would know it. Brian Kemp. Kemp.
Yes, yes,
Brian
yes,
Kemp.
yes, yes,
Yeah, Brian
yes.
Kemp. So, dudes, y'all would trust your government to more Brian Kemp than Stacey Abrams, a sister, an African American sister who's been repping for the black community her whole professional adult life? Really? I don't care what kind of beef you got with sisters. Deal with that some other way, not with voting. Because Brian Kemp and his compatriots are going to pass laws to lock you Negroes up. Excuse me, I'm sorry. They're going to pass laws to put y'all in prison. They're going to pass laws to keep you unemployed. They're going to pass laws to just weaken you further, black men. Don't play into that.
Yep.
Give me Stacey Abrams any day over Brian Kemp. Give me Raphael Warnock any day over Herschel Walker, who's really GOP white supremacist in blackface. There, I said it.
Period. I mean, if you actually listen to what Herschel Walker says, one, I believe he has CTE. I mean, I don't know obviously at all, but it would not surprise me if he has it. Some of the crazy things that he says. And the fact that he, was raised by black people, is a black man, but some of the things he says so goes against what would be helpful for the black community. I mean, it's just crazy and insane. So I believe Raphael Warnock is gonna win though. I mean,
Well,
Raphael Warnock, he's the
Herschel's up,
incumbent.
isn't he?
He's up.
Herschel's
Whoa.
leading, has a slight lead. The last I heard, I don't. But I'm with you. I'm in agreement with you. Let's call it fourth.
I mean, and typically incumbents do better, which obviously is not the case because President Donald Trump just lost in 2020. But you would think that Raphael Warnock being in office for what 2 years would show that he cares
That's
in the
for
bills that
Trump
he
losing.
sponsored. Yeah, yeah. So we'll see, and it's coming up so soon, like just over a month.
Yes, a little bit over a month from now. Y'all got to get out and vote. I mean, you really, really do. Um, I don't our home state here, Chloe. I don't know about us. I mean, we're just in the throes of GOP foolishness right now. MAGA, QAnon, Trump, Boogaloo Boys. I mean, some of these organizations literally started just a few miles away from where we live.
Yeah,
Some of the most strident and most racist people in the country who are actively racist live right here in the DFW area.
yeah,
Okay. And, um, and some of them are confessing Christians. It is amazing how white Christian nationalism has just inundated many, many, many large white churches and of all denominations. And this stuff is just spreading around the country. And what's disappointing to me, as I'm an attorney, but I'm also a minister, and what disappoints me is the silence that's coming from black clergy. I mean, basically hearing nothing. Some of the leading preachers, T.D. Jakes, Nothing. Creflo Dollar, nothing. Bill Winston, nothing. Um, you know, these are the leading voices, leading black preacher voices, and they're saying nothing in response to the white Christian nationalism that's taking over the Christian voice here in America. Nothing, nothing, nothing.
When Christianity is not even, really a white religion. I mean, it started in the Middle East. It was brought on by the Romans, by Constantine. You know, he then made Italy a Catholic nation, but it's not a white religion. It
That's right.
started with brown, tan people in the Middle East. Jesus was at least a brown person, if not a person of African or black descent. So this, just trying to paint it as this white religion is just completely, completely, completely wrong. I mean, Europeans, pre-Christi, pre the birth of Christ, and even after, if you look at the Greek gods that people were celebrating, all the paganism, the Roman gods, what the Vikings were doing. I mean, so to now try to paint it as this white Christian religion and kick everyone else out, it's just lies. It's complete and utter lies.
Well,
And
go ahead. I'm sorry.
no, go ahead, Dad. Go ahead.
Well, I was just going to add to what you're saying that unfortunately, many in the black community have conceded Christianity to whites because you oftentimes hear African Americans, especially young men, saying that Christianity is a white man's religion. The Bible is a white man's book, and they're saying precisely what white supremacists, white Christian nationalists want them to believe, right? That Jesus is white, as you were saying. All the disciples were white. Everybody in the Bible white. When it is false and a farce. But these, so many blacks are conceding and just you know have been misinformed about Christianity. All right, now we're 37 minutes in. We're trying to keep this around an hour. Chloe, the next thing that we're going to talk about, you're going to kind of tell us about bail reform, another very hot button
Yes.
issue in the black community. Take it
Yes.
away.
Bail reform.
Yes.
And it's something that I'm passionate about as well.
Yes.
Being a criminal defense attorney, being a former prosecutor. It is something that unfortunately has become a means of keeping poor people, black and brown people, in jail before they're ever convicted of a crime or found guilty. So we want to break that down and we want to compare two different states on how they're dealing with bail. We're going to compare our home state of Texas and we're going to compare the state of Illinois.
Wow.
So, yeah.
Yeah.
I mean,
This ought to be
kind of two
interesting.
different states. I mean,
Yeah.
one is up north in the Midwest up north. You know, Texas is down here. We like to think we're our own country almost,
Yeah.
trying to succeed.
A progressive governor up in Illinois,
Yes. Governor
ultra
Pritzker.
conservative right wing governor here, Greg
Yes.
Abbott.
Yes. So what is bail? What is bail? Basically, it is typically, okay, let me explain. When a person gets arrested and accused of a crime, the first thing to remember is that person is presumed innocent. Anyone arrested and accused of a crime, the law says you must presume that person to be innocent. And what happens is bail has developed, or it should be a way to ensure that the person accused goes back to court and deals with the case, deals with the accusation that the state or the federal government made against them. And ways that states do that, there's certain ways that a state can ensure that a person accused of a crime goes back and answer for the charges. One of the big ways is money, is making a person pay a certain amount of money in order to get out of jail and ensure that they answer for the charge against them. The issue comes is that a lot of times the people who are accused of a crime or arrested for a crime, whether fair or not, are poor and or are black and may not be able to pay the amount of money that the judge says they have to pay to get out of jail. And that's when our jails become populated with people who have not been had a day in court, who have not been found guilty, who have not been pled guilty, but they're having to sit days and months, even years in jail until the case is dealt with. So that is kind of what a very, very overbroad overview of what the hot topic of bail reform is. Because we know that excuse me, my ear things are coming out. But we know that that is and it disproportionately affects the black community of having to sit in jail and not being able to get out of jail to answer for crimes that they have not even been found guilty of. That's the most egregious part here. Do you have anything to say on this initial introduction, Dad?
No, you laid it out well. There are people who Sandra Bland comes to mind, right? I mean, she lost her life while in jail for $500 is what I heard. Um, I heard her sister, I think, give an interview, and they were, it was $500 could have got her out of jail, and she ends up losing her life because of $500. There have been people who've been stuck in jail because they didn't have $50.
Yep.
Right? I remember one guy said he spent I want to say maybe like 30 days in jail over $30. And
Mm.
and let me just say this and then I'll give it right back to you, Chloe. It makes no economic sense either because holding somebody in jail for $30 when it costs $30, $40 per day to keep them in jail. After 30 days, let's say you spend $50 on them. 30 days of that's $1,500. If you got them in there for 3 months, that's $4,500 that taxpayers spend holding somebody on a $30 bill.
Mm.
That's stupid.
It makes no sense. And it's affecting, all of the citizens because all of our tax dollars are going to keeping this person in jail when it could go to other measures to help more the population of the state. So Illinois has tackled this problem in a completely different way than Texas has. So I want to talk about the way that Illinois has tackled the bail reform problem, which is they passed in 2021 an act called the Safety Act, and it stands for, I have the name here, the Safety, Accountability, Fairness, and Equity Today Act. It passed in 2021 by Governor Pritzker, and a lot of the measures are going to go into effect January 1st, 2023. And one of the big things to come out of that act is that on January 1st next year, Illinois is going to completely eliminate the cash bail system,
Is
meaning
is that for every charge?
that's for every charge.
Wow.
Now, there has been there has
Even I have some concerns about that. And
there
we're criminal defense lawyers. I mean, really? Everyone? Every
everyone,
charge.
every charge. Now, the iteration that passed in 2021, it has gone through a couple amendments in the past couple years
Okay.
because there's been a lot of pushback from law enforcement and other groups as well. Especially on that particular point, Dad, which is eliminating the cash bail system. So for our viewers, what that means is typically when a person is charged, accused of a crime, inside the jail, they go in front of a magistrate or a judge who will look at various facts surrounding the charge and determine how much money that person has to pay to get out of jail. What Illinois has done with this act is completely eliminate the person having to pay cash to get out of jail. But here's the thing that addresses your concern too, Dad.
Okay.
So, so the judge can either release the person
All right.
on their own personal recognizance bond,
A
which
PR
basically the
bond.
person, yeah, signs a sheet of paper and says, "I promise to come back to court and face these charges." Or, and what this bill does is the magistrate can say, "Well, we're not going to allow this person to bond out at all."
Okay. All right.
So even though, yeah,
That makes sense. Okay.
yeah, yeah,
But
but
yeah, I okay, go ahead. I mean, as a lawyer, I still have questions about
yeah,
even that.
there's a lot of questions about it,
Yeah.
because also, so when the person is accused of a violent crime in Illinois, what a lot of law enforcement agencies, especially, and the state attorney general, what they have contested about this bill is the fact that the burden is on the state to prove with clear and convincing evidence that the person accused of a violent crime should not be able to bond out of jail.
So just a clear and convincing evidence standard, not a
Yes,
beyond a reasonable doubt.
not beyond a reasonable doubt.
Okay.
But they argue even that standard of clear and convincing evidence is too high. And the fact that they have to have the burden to prove that the person is a danger to society and the community, they shouldn't even have the burden to do that.
So the state law enforcement, that crowd says having to prove that the person shouldn't receive a bond, having to prove it by the clear and convincing evidence standard is too high of a burden
It's
for
too
them.
high. Yeah. Yeah. Yep. But what proponents of this bill say are that, one, this will help Black and poor populations who, a person accused of theft, or, for taking some food out of a restaurant, or a person with a drug addiction who has a drug offense, like possession offense. They get this cash bail bond. They can't pay the bond. They're stuck in jail for months until they go to trial or something else is done on their case. It relieves that person from being in jail before they're even found guilty of anything. And it also helps the counties and the jails because it relieves the high jail population. And that's true. We know here in Dallas, I mean, the Dallas Frank Crowley jail is overpopulated. There's an overpopulation
Yeah,
issue.
there's a
And
lot of
it's,
controversy going on right now about that
yes,
between the county commissioners and the judges, all of which we know. Um, but yeah, so can I jump in here real
yes,
quick?
please.
Okay, so because I want you to go ahead and compare what's going to, with the reform that happened here. But currently, if somebody gets arrested here for, let's say, a felony two, right?
Hmm.
There's a bond schedule that the magistrate, so they get arrested, they end up at Frank Crowley, they end up at Lou Sterrett, pardon me, and they're within 24 hours or so, they go in front of a magistrate. And the magistrate has the discretion, and most of those magistrates we know um, have the discretion of what that bond should be,
Hmm.
right? There's no mandatory this or that. Now, I just seen yesterday, Chloe, a commercial ad that Dan Patrick, the lieutenant governor here, is running.
Mm.
And Greg Abbott is not really the powerful one here. The governor is not really the governor here for legislative purposes is more sort of ceremonial. It is the lieutenant governor who has the power here in Texas. And I saw an ad he ran yesterday where he said people who use guns while committing a crime will have a oh my God, 10-year mandatory. Oh man, I'm forgetting it. Tony, text me what we because she'll text me. She's the producer. I'm forgetting it. I think it's a mandatory 10 years on that. But let me get back to bail. So the, so the magistrate will have the discretion of what to make the bail. And if it's too high, you and I and other defense attorneys will take the client in front of the judge and try to get the bail reduced. Okay? Yeah, 10-year minimum mandatory sentence for crimes that's a whole nother thing. We'll come back to that. But I mention it because in his ad, he does talk about getting rid of bail reform. Okay? Changing the whole system. And I think that's where you're getting ready to go in a second. But so the magistrate sets the bond, has that discretion. Okay? Then the person's attorney, if the bond is too high, will ask the court to reduce it. The court can reduce it, keep it the same, or even increase it in that hearing. Now, the people who tend to get caught in the cracks are the folks who have, I guess, the misdemeanor cases, right?
Mm-hmm.
And they don't get the court-appointed lawyer immediately. I know I used to do jail chain. You've done jail chain where you go to the court that call you to be on to handle their jail docket that day. You're the defense attorney for all the people in jail for that day. And those people many times would have been in jail 3, 4, 5, 6, 7 days, 10 days before we get them over on the jail chain. Okay? And so by the time they get over to where we are, they may be charged with something like driving with a suspended license and would have spent 5 days in jail over that. And would have lost the job and would have lost an apartment or something or other, unintended consequences, right? And then we get them over there. The prosecutor, most of the time, will plea them out, time served. And here they spent 5 days because their bond was $500. They couldn't get $50. We've seen that. So that's one end. The other end are these folks who are out here committing violent offenses, right? And so I'm thinking of the Illinois system where someone who has committed a violent offense, but you explained though the magistrate still has some discretion. Okay, so
Yeah.
yeah.
And the prosecutors then have to prove to the judge that the defendant is a flight risk or danger to the community. If they're charged with that violent offense, then the judge can issue a cash bail or do some other type of bond.
All right,
But
let me make sure I got this right.
Mhm.
So January 2023, January 1, cash bail is generally done away with in the state of Illinois.
It's abolished.
It's abolished. All right. So somebody get arrested on a serious offense, a violent offense, let's say. The prosecutor has to come in and say, Judge, there needs to be a bail here. Right?
Mhm.
And we think that bail should be this amount.
Mhm.
Otherwise, that person who committed that violent offense
Is released.
is released, although the person is presumed innocent. So that's what's coming.
Yeah.
For
So
Illinois?
a person can only be detained pre-trial when they're accused of a crime if a specific type of offense, like the violent offense, and if the prosecutors prove to the judge that the defendant is a flight risk or danger to the community.
Wow.
Then
That's
they can be
different.
detained pre-trial.
Man.
Yeah.
Man,
Yeah.
man.
Yeah.
That's going to end up at the U.S. Supreme Court.
I think I read that the state attorney general is suing to try to get that bill reformed.
Yeah. I mean, our nation believes in federalism, states' rights. That's written in the Constitution. So the states are going to, have the autonomy to enact what laws they want to enact. But attorneys generals of these GOP states, well, first of all, that's not going to happen in GOP states. So let's that is not going to happen. Nothing nowhere close to that. So in fact, tell us what's going on here in Texas with bail reform.
So Texas has gone the complete opposite way. In Texas in 2021, now they're requiring cash bail for any person charged with a violent offense or a sex offense, and it's called the Damon Allen Act. That act was named after a state trooper who was killed by a person who was out of jail on bond for like assault to a public servant and some other type of violent offense, and he was killed during a traffic stop. State Trooper Damon Allen. So our
May he
governor,
rest in peace.
may he rest in peace.
But how is that different than what we've had already?
Because what we've had already is when the person is arrested, charged with the offense, goes in front of the magistrate did not have to render a cash bail. They could have rendered a surety bond in which the person can hire a bond company
Okay, gotcha.
who'll put up the surety and the person can be released that way.
All right. So in other words, for violent offenders or people accused of committing violent crimes, they cannot get a PR bond, basically.
They cannot get a PR bond.
Okay, gotcha.
Yeah. It has to be a cash bond.
But wasn't
And
that, I mean, like in Dallas County, that was already the case. I mean, Dallas County does PR bonds on low-level misdemeanor cases. Some class A, I think even class A misdemeanors. But somebody coming in there charged with a serious felony, they're not going to get a PR bond. So that
but
was
they may have
already
gotten a surety bond.
okay.
They may have gotten
Wait a minute. All right, wait a minute. So you're saying they couldn't even get a bail's bondsman. I mean, they couldn't like get a bail's bondsman and pay 10, 15, 20% of the bond. They have to do cash bond.
cash bond, cash
Wow.
bail,
Okay.
cash bail.
Gotcha.
And I want to read it because they've updated the Texas Code of Criminal Procedure and I
Yeah.
want to read the language.
Okay.
I just had it
Let me
here.
see if I can bring it up here. Where is it at?
Let me send it to you.
Can you tell me, and I'll pull it up on my iPad and put it on the screen.
Well, it's on the texascapital.gov website,
Okay.
but I just sent it to you. You should be able to bring it up.
And okay, what is the status of it right now?
It was signed by Governor Abbott last year, 2021.
And is it in effect now?
It's in effect now.
Did you email it to me?
I texted it to you.
Okay. So it's in effect right now.
It's in effect right now.
I see it. I got it right here. Okay. All right. So I think I can pull it up here.
And again, guys, we're talking about bail reform, and we are comparing the way Texas has dealt with this issue of bail and when people accused of crime should be able to get out of jail versus the way Illinois has. So we're
Okay.
looking at the Texas version right now. We're about to pull it on the screen.
All right, there it is.
We hope you all can see that.
Yeah, it's a little small.
So really,
I think hold on, Chloe. I think I can change it here. I
okay.
think I can make it larger. Let me just do something real quick there. I think this is it. Yeah, that's better. Okay.
Let me. We hope you all can see that.
Yeah, it's much bigger.
Okay, so this is the language that Texas has enacted in the Texas Code of Criminal Procedure, which dictates the way that criminal cases proceed here in Texas. Um, so it says, except as provided by subsections B and C, unless a person shall be eligible for bail unless the person is accused of a capital offense when the proof is evidence. This provision shall not be so construed as to prevent bail after indictment found upon examination of the evidence in such manner as may be prescribed by law. A person accused of a violent or sexual offense may be denied bail pending trial if a judge or magistrate determines that requiring bail in conditions of release is insufficient to reasonably ensure one, the person's appearance in court as required, or two, the safety of the community, peace officers, or the victim of the alleged offense.
What?
Yeah.
Wait a minute. What? That a person accused. Let me put that back on.
Let's put it back up. This is 87R HB 20.
A person accused of a violent or sexual offense may be denied bail pending trial if a judge or magistrate determines that requiring bail and conditions of release is insufficient to reasonably ensure the person's appearance in court as required, or the safety of the community, peace officers, or the victims of the alleged offense. We got to flesh that out, Chloe.
We
That
do.
is that is consequential. That is big. That sounds to me like it's unconstitutional. I mean, bail is a fundamental part of our jurisprudence.
Now, you know that I feel like what they did to get around that is they included that if line. So if the judge determines one, um, those conditions that were subsequent, I feel like that's how they try to get around.
But Chloe, look at. I mean, I don't know if I don't what this is a person accused,
Yeah,
not a person convicted. A
yeah,
person accused. The person may be innocent. Now, on one hand, someone committing a violent, this is so troubling. Okay. A person is accused of an offense. Our Constitution, when I say our, I'm talking about the U.S. government, the United States of America, as well as the state constitution, talks about bail, talks about being presumed innocent. And I mean, these things are enshrined in our documents. And to deny a person bail, the person, that means an innocent person may spend a year or two in jail awaiting trial.
hmm
Now, I can tell the way the language is written too, that, so let me say this. There are several safeguards here. One is judges will be making this determination. Okay? This will be based on what judges determine. Isn't that what it says? A person
yes,
accused of may be denied bail pending trial if a judge or magistrate determines. All right. So that's a safeguard. All right. So the
hmm
judge really has the discretion here. Okay. Um, and also another safeguard is that there will be hearings on these things, right? And the attorney for the accused will have the opportunity in front of the judge why the person is not. Um, what's the condition here? If the person, why the person is not a flight risk. Okay, that's one of the things to ensure the person's appearance. Well, he's not a flight risk, he or she, and is not a danger to the community. So those are the two things you'd be trying to put forth evidence to convince the judge the person is not a flight risk and or the person is not a danger to the community. Of course, prosecutors going to be over there sharing why they
Oh,
believe.
yep. And in regards to that, the bill also calls for the Office of Court Administration to create a public safety report system in which magistrates who are making these decisions, judges making these decisions, will have the person accused, the suspect's personal information, criminal history, and pending charges.
That's
So,
fair.
yeah.
I guess that's okay. I mean,
And also the bill also requires that magistrates must get new training as well.
okay.
I mean,
Ma-
because this is putting a lot of what's the right word? It's giving a lot of authority to these magistrates and to the judges. And what people don't may not realize too, the magistrates in jail, they're seeing countless people, defendants coming into jail. So I don't know how they're going to have time to flesh out, this person's criminal history and pending charges and all of that
That's true.
to make a lot of these decisions too. But that's where also the person's attorney can then go to a district judge and
Exactly.
have a hearing set as well.
Exactly. That's exactly right. Because that happens now. Magistrates may set a crazy high bond, and we will then walk it through or have a hearing, bond reduction hearing in front of the district judge. Um, my main concern with this language is the fact that the person is accused.
Yeah.
Once and if a person is convicted, that's a whole different ballgame. We don't want violent criminals on the streets. No one in their right mind, including criminal defense attorneys. Okay, we don't want violent criminals on the streets victimizing people. I mean, we don't want that.
Mm-mm.
Um, as criminal defense attorneys, we will zealously go the distance, though, to represent our clients. And even if our clients are guilty, we will still go the distance and zealously so, because they're entitled to certain constitutional rights.
Mhm.
But if they are found guilty or plead guilty, then that's a different ballgame where the safety of the community is concerned. It's the way I see it.
Yeah, no, I agree. Look, we don't want violent people on the streets, especially like you said. I completely agree. If they've been convicted, if they have a history of these violent convictions, period.
That's right.
But being accused of a crime, and we know that a lot of times people are accused based on shoddy investigations. A lot of times people are accused because the police go out and they have to make arrests per their department policy. Um, people accuse others based on just to get back at them, all types of stuff.
Racial profiling,
Racial profiling, all of that.
all of that.
And we know that this is going to disproportionately affect poor and black people.
That's right.
That's
Um,
the issue that I have with it. But I also have to say too, these are both two extremes. I feel like the Illinois act is a little bit extreme as well, even though I mostly agree with it. I feel like what Texas has done is pretty extreme, even though I agree that we don't want violent people on the streets. So I still feel like there's a better way to deal with this bail issue so that it does not disproportionately keep black and poor people in jail when they have not been convicted of crimes.
well, I and I have I got to ask you to keep explaining certain things to me because this language here, a person accused, back, let me put it back up here. Person accused of a violent or sexual offense may be, doesn't say shall be. That would
Right.
make all the difference in the world.
Yeah.
May be denied bail pending trial if a
Right.
judge or magistrate determines that requiring a bail. Ag- my issue is that is not too different than the way it is now.
Right. And for people that don't know, when the law says shall, it's basically you have to do it. Like you shall do such and such or not do such and such. With may, there is discretion, and that's where the protections we were talking about, the judges and the magistrates come in as well. So the
So
judges don't have to not um allow the person to bond out. It's may.
So I wonder were the GOP legislatures here grandstanding a little bit to be able to say, look at what we did, look at this tough measure that we did. Because again, you pointed out that the big distinction here is the bail must be cash bail, not a surety bond, right? But judges had discretion to do that already,
Right. I mean,
right?
yeah.
I mean, that's one the magistrate, and let's distinguish. Let's make sure folks understand. The magistrate is a person who works for the county or the city. You know, they are hired. Whereas in most jurisdictions, the judges are elected.
Mhm.
Okay, they are elected officials, and so the mag judges are typically in the jail where people are arrested, and folks will go in front of the mag court or mag judge, and get their bond. Here we call it a preliminary hearing. You go and you find out um, what you're charged with and what the bond amount will be, and that has to happen within like 24 hours of the arrest. Okay, some smaller counties may be a little longer. Um, but whatever that mag judge set as the bail, like Chloe, like you said, the attorney for the person can go over the mag court's head and by going to the district judge or even the county judge, the misdemeanor judge. The district judge is over felony cases here in Texas, and the um, county judge is over misdemeanor cases here in Texas. But you can go to either one as attorneys on behalf of your client if you think the bond is too high.
Mhm.
And the prosecutors can go to do the same thing if they think it's too low or even ask for it to be revoked. We got a case coming up this coming next week, actually, where the prosecutor is going to ask the judge to revoke our client's bond, put him in jail. We're going to vigorously fight that.
Yeah. So to your point about this potentially being grandstanding, yeah, I think so. Um, you know, Texas Republicans they want to be seen as being hard on crime. And I don't know if they may have used this slain officer's death to try
Oh,
to do that.
I
I would
hope
hope
not.
not.
Man,
I know.
wow. Yeah.
I would hope not. But this is a issue that needs to continue to be fleshed out. It needs to continue to be addressed because who it's hurting disproportionately are poor and black people. So we will continue to talk about it
Yeah,
as
we,
well.
we should drive that point home because if you're poor, if you got means, you're going to get out of jail fast,
Yeah.
right? It's just a phone
Yeah.
call. You're just a phone call away from getting out in a
Yeah.
few hours of process time.
Yeah.
But if you're poor and there's no one to call, I mean, literally, that $50 could keep you in jail in some states for quite some time. And as I tried to explain earlier, it makes no sense when that happens, because why hold somebody on a $50 bond and spend $50 a day feeding them and clothing them and all that? It makes no sense. It's stupid.
This is why voting is important, you all, because who we have in office, the judges that we have, it impacts especially the Black community and what happens to us. This is why voting is so important and why we wanted to talk about these two issues.
Yes.
Voting Rights Act, this case that is coming up next week on the 4th, and then just a month later are the midterm elections. Your vote is important and it matters. And I want to challenge each and everyone listening to this and who will listen to this. Reach out and look up your state official policies and your local representative policies and your United States Senator and House Representative policies, and look to see what they're doing to impact your community and you, because it has a larger impact than what you realize. So that's my
Yes.
challenge to each and every person listening to us.
Great challenge. An excellent job explaining to us the differences between the Illinois law, bail reform, and the Texas bail reform. What basically Texas did was, yeah, we're going to reform our law, right? We're going to reform it in a way to make us look tough on crime.
Mm-hmm.
Okay. So this has been great discussion, Chloe. Thank you as always for, bringing that young mind. Here I'm sitting here trying to remember Bryant Kemp's name.
I couldn't remember either, so we in the same boat, Dad.
So yeah, excellent. I enjoyed that discussion. So folks, please subscribe, like, share. Please, 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 please.
We're trying to reach 5,000 subscribers. By the end of the year, we can do it. We will do it. 5,000 subscribers. Share this video. Share our channel. Tell people about us. We want to build up this community. This is why we do this.
Yeah, your mom made a good point. She texted me and said that this whole bail thing, whether someone get bail in a state like Texas, or what type of bail reform the state ends up doing, depends on whether or not the place is liberal or conservative. And no one's freedom should be based on that.
No.
But that's the way it is in this country right now. Anyway, thank you for tuning in to the Defiant Lawyers. Help us reach that 5,000, Chloe, I think we need to do a giveaway.
Yeah, let's do it.
Yeah, I think we need to do a giveaway. You all, we love you. We appreciate your support. Let's grow this channel. Let's get this information out. This is the channel for the intelligent Black person who wants to be in the know. Yes, that's who we are. Look, we enjoyed it. Thank you for tuning in. Chloe, have a good rest of your day, although I know we got a lot of work to do.
Oh, Lord. Yep.
We're out of here.
Pray for us, guys.
Bye-bye.
Peace.